considering the most important news from the last week. One is with respect to the relation between the central and the state governments, and the another one is with respect to the controlling of the digital intermediaries in India. Welcome to another episode of Weekly Current Affairs from Amrita IAS Academy. Myself, Manish Nambiar. I am the faculty for Indian Polity and Governance. Imagine a situation where you are buying something from an online platform. Say for example, you need to buy a shoe. So once when you buy that shoe from the online platform, then later you got dissatisfied with that particular product you have purchased. So what will you do? So you will make a complaint to the digital intermediary or the particular platform through which you have made the purchase. And what will happen if the platform says that, sorry, there is nothing we could do, you have to bear the cost, because the company which sold the product, we are not responsibility for their responsibilities or their matters. What if such a thing happens? This is what we are going to discuss first. So starting with a news which I have seen in the last day was that the government is examining if Meta is crossing into a role of publisher. So that caught my eye. So this was something which we always used to discuss when we discuss about the rights of the digital intermediaries in India. So some of you might be having an idea about what I am about to discuss, or some of you might not be. Let us forget all these things. So we will start afresh. So if you look at the Information Technology Act or the IT Act. So according to IT Act of India, the Act is aimed at ensuring the protection and the rights of the Indian citizen when it comes to the digital world. And there, the IT Act is protecting the citizens of India, and mainly citizens when they are acting as the customers in the digital platforms. So IT Act is protecting these customers or the customers in the digital world, preventing their vulnerability to frauds, preventing the issues of extortion or any kinds of fraudulent activities which can happen in the digital world. So because of this stringent rule, the digital intermediaries or the digital platforms which are giving you services, they were reluctant to participate in the process. That is, you are the customer, you are getting a service from a company, but this company is providing the service through a digital platform. Say for example, it can be Flipkart or Amazon, or it can be Google, Meta, or the Facebook, or any of these platforms. So company selling something to the customer through the platform. So IT rules or the IT rules and the IT acts are meant to protect the customer. But so as to protect the customer, some restrictions has to be placed upon the company as well as the platforms. So because of these restrictions and the rules, the companies and the platforms were reluctant to participate in the digital processes. And because of that reason, to ensure their participation in the digital world and ensure their participation in the e-commerce market of India, what the government of India and what the Parliament of India had done was, a section was added, section 79 to the IT Act. So the section 79 is an exemption from liability to the intermediary. So again, I will draw the diagram for you. There is a company who is selling some products to the customer, but in between the company and the customer, there is a digital intermediary. So section 79 of the IT Act is actually giving a protection to the digital intermediary, and the liability is directly being transferred to the company rather than being transferred to the digital intermediary. So that is the purpose behind section 79 of the IT Act. So if you purchase something from Flipkart, and if there is any issue with that particular product which you have purchased, the responsibility is not on the Flipkart, but it is on the company from which you have made the purchase. So that is simply speaking section 79 for you. So now going back to the issue with the Meta platform. So currently the platform Meta is identified as a intermediary as per section 79 of the IT Act. So what will happen then? If Meta is recognized as an intermediary, anything which happens in the platforms of Meta will not be responsible. Instead, the company which publishes this data, only they will be made held responsible. But now what is the issue? Nowadays, by Meta being an active participant in the advertisement world, Meta can control which product should be shown to you. Say for example, if you are searching for a refrigerator, Meta can push forward a particular company. You might have noticed that when you are searching for something online, say for example, if you are searching for something in Google, some products will be shown to you as the first priority and there will be something written as advertisement. It will be written in such a manner. So through that process, the company Meta can decide which should be shown to you first. The prioritization of the order can be done by Meta itself. So it is because of that reason, see what will happen when there is a change in priority? Obviously the choice of the citizen will be affected because of that reason. So that influence can be done by the digital intermediary. So now the government is examining whether the platforms which are handling such control over the publication of data should be considered as an intermediary or as a publisher. So now in the particular case, if Meta is considered as a publisher in future, now what will happen? Their exemptions or protection under the section 79 of IT Act will be taken away, and henceforth if such a thing happens in the future, Meta will be held accountable for the things which happen in their platform. So that is the simple news which we have to discuss here. Now related to this particular matter, there is a judgment of the High Court of Delhi which we have to refer. So as to augment our preparation, Christian Louboutin versus Nakul Bajaj case of 2018. That is one important case which we have to know in this matter. So in this particular case, 3 conditions were set by the Delhi High Court. So the Delhi High Court said that we need to distinguish whether the intermediary is active or passive. Or in other words, I will simply discuss with you what is meant by that. Say for example, let us consider 2 intermediaries which are giving services to the customers through their digital platforms. First one is intermediary A and the second one is intermediary B. And now if you go to intermediary A, you will have the products of different companies and also you can also see the product of this particular company, which means they are also selling their own products in the particular platform. Or in other words, they can influence the pattern of the advertisements. In either way, they can be considered as an active intermediary, where they are not acting as just a service provider, but instead they are actively controlling the market. Now comes type B intermediary, where they are not providing anything else but only a platform for different companies to publish their sales and all these things. So they shall be considered as passive intermediaries. Now Delhi High Court had said that section 79 of the IT Act and the safe harbor provisions which are given to the digital intermediaries shall be applicable only for passive intermediaries, because they are not active players. So only they should be protected. Active intermediaries need not be protected. So that was the first guideline given by the Delhi High Court. Now comes the second one. Even if it is a passive intermediary, they have to ensure mandatory due diligence. Or in other words, when a passive intermediary is publishing the advertisements on behalf of other companies, they have to make sure that the details of the seller, all these things should be done. And also, they will be losing their safe harbor immunity if they do not make proper verifications. So this was the judgment given by the Delhi High Court in the Christian Louboutin versus Nakul Bajaj case of 2018. I hope you got a clear picture. So let us see through a diagram, let us see which all intermediaries will be getting the safe harbor provision. So if you consider the 2 types of intermediaries, active and passive, an active intermediary will not be given the protection under the safe harbor provision. Now when it comes to passive intermediaries, there can be 2 situations. One, due diligence is done. In another case, they are not verifying their sellers. If the sellers are verified and due diligence is done, then safe harbor provisions will be applicable. Otherwise, it won't be applicable. That's it. As simple as that. Now let us look at the next news which is important for our current affairs. So that was with respect to the singing of national song and national anthem in the state assemblies and the parliament and in the public events with respect to the event of August 15th, that is our Independence Day. So we know that Independence Day, Republic Day, or be it any other type of public events, during the public events, national anthem has to be mandatorily sung. And recently, the Government of India and the Parliament of India had passed the Prevention of Insult to National Honour Amendment Bill of 2026. This particular bill has been passed by the Parliament and we have discussed it too. So, as per this particular bill, national anthem and the national song, both of them will be given same legal protection. That is, if any of the people in India does anything which is insulting this national anthem and national song, they will be put under the jail for criminal activity. So that is the new amendment bill which is saying. And along with that, a new order was issued by the Ministry of Home Affairs. So the Union Home Affairs Ministry, they issued a new order relating to the singing of national song. And according to that particular government order, in a public event, or be it an event which is attended by the President of India or the Governor of any states, in that particular situation, both national anthem and national song has to be sung. And the conduct of people during the singing should be the same. We should be standing in attendance. We shall not be disturbing the process of singing. We shall not create any insult to the national song as well as the national anthem. And the full national song, the 6 stanzas of national song has to be sung during the event. So that was the guideline given by the order. And there is one more thing, that while singing both of them, national song and national anthem, national song has to be sung first and then national anthem has to be sung. So that is a guideline given. Now, this particular news says that in Tamil Nadu, a new resolution was passed. And what was that resolution? That they will be singing the state song, that is the Tamil Thai Vazhthu. It should be sung first before singing the national anthem and the functions. So, this particular news created confusion among many students, and they were asking, sir, can the states in India act against the direction given by the sender? Will there be any legal repercussions to that? So, let us examine what will happen in this particular situation. So, we have discussed what the executive order of the Ministry of Home Affairs and the Prevention of Insult to National Honours Amendment Bill 2026 had to say. Now, let us look at the constitutional position, starting with our ideals of federalism. So, the ideals of Indian federalism says that our India, that is Bharat, shall be a union of states. That is Article 1 for you. Besides that, we do not have any equation to understand the relation between the center and states in India, except the provisions of Schedule 7 or maybe any other articles. So, according to Article 1 of the Constitution, India, that is Bharat, is a union of state. So, what does that mean? Union of state is a term which connotes the relation between the center and the states. And accordingly, in India, if you look at the federalism, it is federalism with a unitary bias, where the center has more powers when compared to the states in India. And accordingly, according to Article 256 of the Constitution, the central government can issue executive directions to the state governments with respect to the implementation of the laws of the Parliament, which means whenever a law is passed by the Parliament of India, central government will give executive directions to the state governments on how this particular law has to be implemented. So, when the Prevention of Insult to National Honour Amendment Bill will be passed, what will happen? The central government can give a direction to the state governments, and the state governments has to mandatorily obey that direction. If they are not obeying that particular direction, it will lead to a violation of the constitutional mechanism of the relation between the center and the state. It will invoke Article 355 and 365 and in turn can cause the invoking of Article 356 of the Constitution, that is a state emergency. But here is a key takeaway here. Article 256 of the Constitution is dealing with the power of the executive. The union executive can give directions to the state executive with respect to conduct of matters. But what if the state legislature is deciding to do something, will Article 256 apply to the state legislative assembly? There we have to understand something. According to Article 208 of the Constitution, each and every state legislative assembly in India have their own powers to make rules of procedure. So they can decide what should be done within their own house. And at that point, the Parliament of India nor the union government can intervene and tell them that you have to do these things. So Article 208 of the Constitution says that state legislative assemblies has the power to make rules of procedure for their own matters. So they can decide whether national anthem has to be sung, whether the national song should be sung, or whether the state anthem should be sung, and the order of singing this, that's up to the state legislative assembly to decide. And they can decide these matters through a resolution, and simply that has happened in the Tamil Nadu Legislative Assembly right now. So that's it. Article 256, which empowers the union government to give executive directions to the state governments, is not applicable to the state legislative assembly because that is a separate body. It do not function under the executive relation between the center and the states in it. That's it. Simple matter. But what will happen if the governor is attending a function within the state legislative assembly? Now there is a conflict because governor, even though the governor is the head of the state executive, governor is also the representative of the center. Governor is a representative of the President of India. So what will happen? Still a question before us, and let's see what will happen in such situations. Thank you.
Amrita IAS Academy.